The novelty check is done through the help of prior art search. While doing the prior art search, or before doing the prior art search, we have to really crystallize the technical matter of the invention. We have to find out the prior art or related art to the invention. And we must distinguish all of the prior art technically with the given invention to establish the novelty. Now, what can be a prior art? Any information which is in the form of electronics or in the form of text or paper media, but which is published or used or documented prior to the filing of our invention or prior to development of our invention. These all shall be considered as prior art. Wait a while, I am suggested to disable the annotation. Okay, now when I'm finding the prior art from, where would I go? It's a big world. So the prior arts are available, thankfully, on internet in a big way. So all scientific papers, articles, your news, various teaching materials in the form of text or in the form of videos, the products, etc., would help provide you the documents for the prior art. At the same time, the patent documents shall also work as prior art in the form of granted patents. It can be expired patent or it can be published patent. Kindly remember that you are going to do the global search to find novelty. At the same time, you're going to file it locally. Sunil bhai, can you please help me to stop this annotation because my screen is being scribbled. Okay, summarizing my earlier slide, I would say that please do not publish first. Publishing your invention will destroy to get the grant of the patent forever. And do not delay because the philosophy is first to file. So kindly first file and then publish. As simple as that. It's in security. I've been suggested by various participants to go and stop the annotation. Sunil bhai, can you please help me?
I'm trying to do it. Just a second.
Okay. So when you tell me, I'll start.
On your mid-teen only, you have to stop annotation on your side on the share screen.
Hope it shall work. Okay, I think it should work. I've stopped it. So now when we recall the criteria, there were three criteria: novelty, inventive step, and industrial applicability. We have already talked about novelty. Now I'm going to touch upon inventive step. Legal definition is there, which says the invention must consist technical advancement. Something better must be there in compared to whatever is already done. That is called existing knowledge or prior art. Or it can have an economic significance of the existing knowledge, or even both. But at the same time, the person skilled in the art, that means person of your caliber, should not feel that this invention is simply doable. He or she must feel that there is really commendable scientific efforts and must contain something called wow factor in your invention. Now, how would we decide this kind of wow factor? To really make it possible, this is how we look at every invention. In a given invention, we try to figure out which problem one or more are identified and what kind of solution is provided. Now, the way to arrive to that solution is something to be patented, or that only can be patentable. Now, that way to arrive this solution must contain a kind of a long felt need. That means the problem is not solved for a very long time, or you are going to provide a very unique technical solution to a given technical problem. It must be non-obvious, or it should have significantly economically good in the invention. So all this is proved over, all is required to be proved over the existing technology. Now, how would I really do it? So I've tried to put a simple example here. We had worked with fire extinguisher, and this is one of our granted patents. The given fire extinguisher claim that they can work with any kind of fires. So my technical problem is, can anybody work with all kind of fires? Yes. So experimented with all solutions in the form of the kettle. So there are water-based extinguisher, there was based dry part categories of could solve one or more type of fires, but not all type of fires. At the same time, the invention could extinguish all types of fires. Now, if I can establish this, what I'm going to prove is I'm proving that I'm solving a technical problem and providing a technical solution which is unique, which is unexpected, and thereby it is inventive, right? If I look the same in the form of or in the category of chemistry, here what my claim is, my given invented process is using only 315 ml of water. At the same time, the prior art is using 1500 ml. So I'm significantly reducing the water usage. And I'm significantly reducing the effluent generation. So there are two problems I'm meeting with and providing a solution which wasn't earlier available in the market or in the prior art, and thereby making it novel as well as inventive. So this is how I have to really differentiate between or amongst prior arts in compared to my given invention. My last requirement is capability of industrial applicability. That is also defined that it must be capable of being made or used in industry. Thereby, if it is not possible to be made or used, then what is the purpose of doing the invention? What is the purpose of rewarding a patent? Now, we might wonder that such inventions really happen. So I've tried to use an example which claims about a perpetual motion. Now, any product or any apparatus with perpetual motion is of no use to the industry. My fellow participants would definitely agree with me. So the objection which came to us was, yes, there is a novelty, there is something great, there is no inventive step because we didn't solve any problem. At the same time, there is no industrial applicability because it claims perpetual motion. So the perpetual motions are not to be used in the industry or not to be manufactured also. So such inventions are not granted patent. So I think I am clear with these three criterias. Now what is next? Now I'm wondering that is necessarily my invention to be new or breakthrough, or can I really claim the improvements? Here I would like to clarify to my participants that the new or breakthrough technologies are patented At the same time, improvements are also awarded patent. Both these categories are treated equally. A patent is a patent in the eyes of Patent Act, no matter whether it is breakthrough or improvement. It is just your write-up that would decide whether it is an improvement or breakthrough. With this clarity, my another set of question can be, what form of inventions are to be applied for patent? So I've tried to summarize, which says a product or a process can be patented. It can also be a machine or apparatus. It can be an article of manufacture, composition of matter, and the most interesting is the combination of any of the above is also patentable. Hope this point is clear, and I'm moving to my next slide. The word COVID-19 is really prevalent these days. And we are wondering that some miracle or some magical products or some magical remedies come out and we really get out of this pandemic. Now, what those magics, or in which category those magics can happen, which will help us? I'm talking or thinking in terms of the patents. So let's say if there are test kits which is developed, it shall be filed under the product patent. If there are sophisticated machinery or devices which are there to provide you the analyzing or testing kits, that shall also fall under the products. All the antidotes, drugs, etc. would fall under the category of pharmaceutical. That's also a product. And ventilators and other medical devices would fall under the machine or apparatus category. Here, each and everything can fall under the patentability, considering they are novel, inventive, and industrially applicable. So like if I want to file an application for ventilator, which image is on my right hand side, but the actual drawing would look like the image on my left hand side. If I'm using a wearable device, its drawing would look like this, which would have different parts numbered, labeled properly. Then I have a drug, then I am supposed to provide the molecular representation of the same, not the actual drug. I have a user-friendly solar system, wherein the brochure looks like the image on my right hand side. The drawing of the patent would look something as an image on my right hand side. I'm trying to make you familiar to how it is going to look like. Now I've almost made my mind that I'm going to file a patent. I'm a little bit clear with nuances of the patent, but I want to check the exception or cautions. My cautions are a section called Section 3 of Patent Act, which describes what are not invention. I'm going to go through them a little bit quickly. The examples are also there on the screen. I would little bit go faster here. This screen is really helpful to me to decide whether my invention falls under this Section 3 or not. If it falls, I'm really excluded to be granted the patent. Let's say my invention, if is contrary to naturally established laws, then my patent shall not, the invention shall not be granted a patent. So the frivolous invention or inventions contrary to well-established natural laws are not granted patent. I've used an example saying that if a machine which gives 100% performance or perpetual machine shall not be granted a patent. Then my second exclusion point is if it is contrary to morality or public order. So the inventions like gambling machine shall not be awarded patent. Another exclusion is any scientific principle or its mere discovery or any abstract theory shall not be granted any patent. So Newton laws shall never be granted the patent, but at the same time, if anybody develops an invention which is in the form of a product which is based on the Newton laws, it can be patented. So the theories, they are never patented, but the objects, the products are always awarded patent. So such objections are there when you file a patent application and when it is examined. The next exclusion point is if you are claiming a mere discovery of a new form of a known substance without proving the efficacy, the patent is refused on basis of this exclusion point. Big judgment was given in the case of Novartis, while section 3D was not met with. Many of my participants might be knowing about it. So there is a detailed explanation, but the summarizing it, I would say that one needs to provide the advanced efficacy. Any mere admixture of known components, two or more, shall not be granted a patent. Meaning thereby any recipe can also not be granted patent because they are considered as mere admixture of different ingredients. So we got such objection when we try to do so. This is also interesting. Any arrangement or rearrangement or duplication or greeds shall not be granted patent. When two or more different devices can work individually, and if you try to club them and claim a patent for the same, it shall not be amount to a patented article. Method of agriculture or horticulture. The process for medicinal or surgical treatments shall not be granted patent, but at the same time, medical devices are always awarded patent. Any plants or any animals in whole with seeds, varieties, etc. shall not be granted patent. Rather, these subject matters falls under protection of plant varieties and farmers' right. Most interesting and most debatable, called computer program per se, are not patentable. Now, I really have practiced that computer program per se is definitely not patentable. Parallelly, there is a computer related invention guideline, which we call CRI guideline, which simplifies or make it understandable that what is not computer program per se. And if your given invention is meeting with these guidelines and not amounting to computer program per se, then the even computer programs shall be granted patent. Mathematical method or business methods and algorithms are not patented. I repeat, algorithms as it is shall never be granted patent. Any literary or artistic representation shall fall under copyright. It shall not be granted patent rights. Any method of or rule of performing mental act or game shall not be granted a patent. So any games shall not be granted patents. They shall be protected under different aspects of intellectual property rights. Presentation of information shall also be not granted patent. The integrated circuit shall be taken care separately by Semiconductor Act, but patents shall not be granted. One of the warning section called traditional knowledge. Traditional knowledge in its original format or its admixture shall never be granted patent. But at the same time, if you provide a new process or product, something like extraction of any extraction of curcumin out of this turmeric, so new processes shall definitely be granted patent. So with section 3, if any of this objection come, then patent shall not be granted at all. So before filing a patent, we as attorney really make sure that the given invention should not fall under any of the subsection of section 3 to ensure the patentability rights. Now, I broadly understand that let my invention or my invention is already meeting with the section 3 exclusion. There is no exclusion. I can positively go ahead. Now I'm excited. I want to file the patent. Now what's next? Of course, my first would be filing. Great. So my first step on the left-hand side is filing of the patent. Wonderful. It is done. Next stage would be publication stage. The third stage would be examination. The fourth stage, which is optional, but most of the time it is actionable, is hearing of the patent application. And my last stage is the order of the patent, which can be positive, that is patented, or negative, which is rejected. So these is the broader steps covered in the patent prosecution. Just remember one thing, this is a legal procedure. Whenever there is a legal procedure, it always form of requisite form, comes along with requisite fees, and it always comes with timeline. To keep 3 things in mind while going through the prosecution of patent: the right form in the right, and of course the forms must be filled up with the right and true details. It can't be false or forged, otherwise it would amount to legal actions. Then I have to submit the forms along with the respective fees. If I fail to pay the fees, then also the forms will not be accepted. And within the timeline, if I miss the timeline, my patent application will be abandoned, and that is forever. So timelines has its own role to play. That is what I want to depict through this particular slide. They're very essential. So kindly even reverse count, keeping the timeline into mind while you are prosecuting. So having understanding of timelines, forms, and fees, now the real stuff starts, called the patent specification, the disclosure, which I want to submit, or I have to submit along with my patent application. I have 2 stages. The first stage is provisional specification stage, wherein I would be at least disclosing 20% of my invention or the underlying idea of my invention. Within 12 months, as per the Patent Act, I'm supposed to complete and file the complete specification with its full disclosure. So my timeline is 12 months, and I'm supposed to do it only once. I cannot refile it, or I cannot amend it. I can amend it a very, very little bit correction, but significant amendments are not possible. So this 12 months are very important. I repeat, we are going to file it within 12 months. Thereby, you can file it even the next day. So let's say you file provisional specification on 10th of April. You can file complete specification even on 11th of April. So it is within 12 months. But my deadline is 10th April 2021 for complete specification. So the next day, if I file, that is 11th April 2021, then my complete specification will not be accepted at all. Right? So the word within 12 months is important. Earlier is always better. Even other timelines are there. One should keep in mind while prosecuting the same. It is filing date to request of examination. I have only 48 months, no more, no less. If I receive an examination report, I have to reply within 6 months. Renewal is something when the patent is granted, which you have to file every year up to 20th year of it. So if we recall what we have gone through, we have gone through the patentability criteria. We have gone through the patent process. We have gone through what form of patent can be filed. We have gone through various exclusion which prohibits me to grant a patent. We have also gone through the timelines which are important along with their forms and fees. Now, if I look at this timelines, I've tried to depict it in the form of some dates and events for a quick reference. So one case study I've picked up with the given patent number. Wherein I first filed the provisional specification in 2016 August, followed by complete specification. Then we filed request of publication. My patent application was published, followed by we filed request of examination. Then I received the examination report, which was to mandatorily file within 6 months, which we file within given time. Then we received some subsequent examination report, which we also filed within given time. And then the patent got granted. So this was the one case where the various dates and events are summarized. There's another dates and events with the similar events, wherein I had a variation called hearing. After the examination report, we got to have hearing. And after hearing, the patent was granted. Now, there are various myths and facts around this. My participants would agree with me that the prominent myth is the patent is lengthy and cumbersome. But if the invention is really new and it has patent, the grant took place in 2018 June, so it was less than 2 years. So my point is it is possible and it is not lengthy. There is much hindrance and blocks in getting a patent. It is not so. If it is really has another myth is filing a patent is costly. I would say the cost is really less as compared to what the benefits one gets eventually. And rights of the patent will start once the patent is granted. This is a very prominent myth. The reality is the rights of the patent starts once the patent is filed. Right? So few myths and facts I've tried to summarize here. Now I'm excited. I want to write a disclosure so that I can file a patent application. So my few homework is I have to prepare the technical differences. I have to really make sure to figure out the technical advancement, one or more, and long felt need, if any. Now this thought shall lead me to the topic called drafting of patent specification. Entire section is kept for that, called section 10, with the prescribed rules, which ask you to provide your specification in a given format. Two types of specification as earlier discussed. First is provisional, where you are required to provide the brief description against which one receives the priority date. And claims are generally not included in the provisional specification. Now, the complete specification, which has to be fully, properly written, which must describe the invention, its scope, its claims, etc., which refers to as complete specification. Now, the one point I've tried to highlight is both the specifications are permanent and they are really separate documents from each other, but the provisional is a base, the complete specification is its extension, and they both should be talking about the same invention or the same scope. If they do not, then the patent application shall not be accepted. Now, this is how we visualize the provisional specification is technically high with various topics or titles in the specification. Complete specification is generally backed by drawings, if any, even supporting data, and the claims compulsorily. So to be precise, the contents of complete specification is something like this. The list is which you can see on the screen. Section 10 says the complete specification must discuss the invention with the help of description, and it must defines the boundary of the monopoly or legal rights with the help of claims. Now, while I'm doing the drafting, I have to be a little bit careful about certain points. I always have to mention the newness of the invention over the existing technology. I must provide all possible variations, which are referred to as embodiments in the patents, as many as possible along with this particular application only. I am not required to file new application for those variations. I'm basically expected to provide variation in the same patent application. I must use the right words, the terminology, and the sentences to describe the invention. And I should not use the vague or overlapping terminology. Whatever words I'm using, I had to be same throughout my description. Every time I have to make sure that I am not infringing any other's patent, because that would destroy the patentability or novelty criteria. So the Act says it has to be sufficient, disclosure is expected. Hiding or not providing enough information shall hamper the grant of the patent. I must provide working of invention, and drawings, etc. are all expected, if any. So sufficiency of disclosure would cover various points. These are not prescribed, but this is a matter of experience and practice, that while including the examples or experimental data like tables, graph, etc., would enhance the strength of the given specification and help think about patentability or positivity of the grant of the patent. So while I'm preparing the drawings, if I log drawing that is not to be filed along with the patent specification, what I'm expected to file is the line diagram or the perspective view, the parse supporting data like this table, which we already referred earlier. This is basically a supporting data to prove that, look, I'm better, look, I'm novel over the patented prior art, and thereby we pray or request the patent office to grant us the patent. The last and most important legal aspect of the specification is claiming an invention. So claim has to be drafted properly. It's a techno-legal segment. It defines the scope of the invention. But what is required is you have to be really clear and concise. You have to be definite and precise, and it must be supported by the specification. While writing the claims, I'm not going to use any foreign word or phrase or sentences which are not there in my description part. So the importance is it determines the scope, decides the essential elements and legal rights. It also determines the extent of protection, the monopolies, and these are something which are used to decide the infringement. Simplifying the same, if there are two different patents before the court of law, the court of law or the respected honorable judge shall compare claim of one invention to the claim of another invention. So claim are something to different types of claims are there. Broad claim is generally the claim one, the first claim, the most important claim of the patent specification. Further you go, it becomes the narrow claim or the specific claim. In the entire procedure, we have to explore a lot. My dear academicians and researchers have already into the practice of exploring the details. So it's not a new thing for them. Even while publishing any paper, you do a lot of exploration. So exploration is, I think, not new for you. Even you have to work at a very low level detail. That is also something not new for you. But what is little new for you is you are not expected to make any mistakes. Like if you publish and then you file the patent application, this mistake is not something you are allowed. So various mistakes here are listed down which are not supposed to be executed by you if you want to get a grant of patent. And when you write the claims, it has to be really definite. So these two segments are something new for those who are filing the patent application for the first time. Now, while I'm preparing, writing, and filing my patent application, I must keep this also in mind that I'm respecting others' patents' right also. The way in which my patent application or my invention is very dear to me, very precious to me. Similarly, other has also the same feeling and same importance for their patent rights. So I must respect other. I unknowingly also should not infringe anybody's patent rights. And the caution is, if you do so, even unknowingly, you might invite legal action because the Patent Act clearly gives the exclusive right to all the patent right holder, all the patentees. This earlier point is a thought which you have to keep in mind while preparing the patent specification. So my proper drafting will be something which will lead me to the successful grant, successful implementation, and it will not invite the worries of infringement and other legal actions. Now this is, we call a patent cycle, where from my first point called identifying and nurturing the IP or patent portfolio to its protection and defending, at every stage, what I have to keep or what shall help me throughout is the patentability. So for example, if I'm identifying my invention, I'll ask myself whether this given invention is novel, inventive or not, industrial applicable or not. If so, then only I'll create a product out of it. I'll rather file a patent application out of it. If not, I'll keep that particular invention out of the list. At the time of prosecution, the same questions shall be asked by the patent office. May you file it nationally or internationally? The same questions are going to be posed. While you defend or while you have the patent watch also. You have the same questions in mind. And by any chance, if your patent application is opposed or even it is filed for the revocation or any litigation, the same questions are going to be asked too. So having the clarity on this patentability criteria shall really help you to understand it throughout its lifespan. Now the procedural aspects are, you are supposed to file the forms. Now forms will expect certain procedural or clerical details. Those details shall be your names, your type of entity, your origin, that is your nationality, details of inventors, etc. So the next question come in mind is who is an inventor and who is an applicant? Are they same? Are they different? What can be the scenario? So an inventor is, of course, necessarily has to be a natural person. But the applicant can be a natural person, at the same time can be a legal entity like an institute, a university, a college, a trust, a company, etc. Now, inventor is considered to be the first person having right over the grant of the patent, grant of the invention. But inventor is one who actually passes on the right to the applicant by means of assignment, by means of the employee contract, etc. Inventor is someone who really conceives the idea and reduces the idea into practice. And applicant is something who is possessing the rights of the entire patent application. There's a brief clarity over inventor vis-a-vis applicant. Having this clarities of even forms, I think my forms are ready, my specification is ready, I'm filing before Indian Patent Office through e-filing, maybe without any help of attorney, that is, I am filing by my own self or I'm filing with the help of attorney. These two routes are only possible. Physical filing is discouraged significantly before the patent office. So online file is something which is expected, and the payment of fees are also have to be filed completely online. Once you file and it is published, you can really go through your progress of patent application dynamically. Up-to-date records are being maintained by patent office and which you can really rely on. So thankfully my filing is also done. I have a lot of clarity over the nuances of the patent. Now I really want to see some case studies, and I'm very glad to pick up a case study of Pandit Dindayal Petroleum University, that is PDPU, which we had worked recently. So a patent application was filed in 2017, as you can see from its application number. Eventually the patent was granted. So I'm mentioning the patent number. Here the applicant is Pandit Dindayal University. And if you look at its type of the applicant, it is an established under Petroleum Dindayal University Act. So it's an institute with its proper address mentioned in the Form 1, which is on my right hand side. Right? Now, why was it granted patent? What was so great about it? So here I've tried to summarize it, that these are the key points which led the invention towards patentability. So there was a process for doing so. And the key steps were this. And out of those key steps, a few were very important, which provided the better efficacy or significant performance of this process. Having this experimentation and data backed up, which is mentioned on my left hand side. Another study which is admirable single professor named Mr. Ravi Kumar has already acquired some 55 medical devices, the patent protection for some 55 medical devices, a notable achievement, I'm sure. And out of them, a few products, some 5 products are already in the market and generating revenue. So this is quite inspiring story. And let us all learn from him and think of filing patents and making it market or society available, and at the same time generating good revenue out of it. Case study of IIT Madras. You can see the numbers. They are making technology patented, and then they are transferring it in the form of technologies transfers and getting royalty. So an institute per se can also be enriched by having the patents and having good technology transfer possible. Now, what you can transfer is what you already possess. What you can possess is what you have the property. The property here is intellectual property. The property here is patent rights. They are legal in nature. So if you possess patent rights, then only you can transfer it. Your exclusivity will get royalties, right? So my first job or first task is to file the patents, make it grantable, take it towards grant. That particular asset or property can be commercially used in the means of technology transfers, license. So with this note, I quote our stalwart Dr. R.A. Mashelkar's golden words. He says that there are 3 P's: patent, publish, and prosper. And he also emphasized not to change the sequence, meaning thereby if you publish and then patent, he is very confident and sure that you will not prosper. So with his golden words, I end my session, and thank you so much for your kind attention. It was a virtual session, and I'm sure I've touched to your requirement, touched to your heart, touched to your thoughts about the patent filing, and I made you thought or think about the patent. Thank you so much. Thank you, organizers, PDPU, IPPO. Thank you so much. Now I'm passing on to Sunil ji or Madam Anjula to take it forward for the question answer.
Thank you, Dr. Ma'am, for the interesting session. Now I request all the participants to put your questions in the chat box. Please put all your questions in the chat box so we can take some of the questions. Please put your questions. I request all to put only important questions and not the written. So we first take the question instead of focusing on the written. I request all to put only questions, please. Anjula ma'am, please take the start with the question answer session. Anjula ma'am.
Hello, am I audible?
Yes, ma'am. Ma'am, please start with the question.
All right, great. Gopi ma'am, am I audible to you?
Yes, absolutely.
Okay, so the first question is how the educational resources like concept-centered experiments developed and not existing in the market have to be patented.
Can you repeat?
How the educational resources like concept-centered experiments developed
Hmm.
and not existing in market have to be
Hmm.
patented.
So educational concepts are nothing else but the presentation of thoughts. There is no product, there is no process which is scientific. It's they are the concepts. They shall not be granted patent. They shall be covered under copyright.
The second question we have is ideas and information comes under patent or copyright.
So the question itself has two different points called patents and copyrights. So can you repeat the question again?
It's ideas and information comes under patent or copyright.
Okay, sorry, I'm sorry. The idea is the preliminary requirement towards patentability, but the feasible products or process shall be filed for the patent application. Information or the expression of information shall be covered under copyright. That is maybe databases or websites or news, etc. shall be covered under copyright.
What is the methodology to check copyright of research?
How if we focus on only questions of the patents?
Patenting. Yeah, I can understand. Can we publish after filing the patent?
You have that inherent right to publish. So after patent filing, you can publish in any format. The publication can be before the publication journal platforms. It can be a commercial advertisement. It can be a YouTube video. It can be a news interview. It can be an invoicing of a product, etc.
One more question. What is the difference between national and international patent?
Basically, that itself calls for an entire session of at least 1 hour to differentiate between national and international patent. But just to give you a few lines answer is national is something we are filing before our mother country. So being an Indian, my mother country is India. So I have to file before Indian Patent Office. Whereas the international applications are considered to be filed before the United Nations body called World Intellectual Property Office, WIPO. Under that, there falls a category for patent called PCT application. So that PCT application shall be filed followed by the Indian patent application, keeping or tuning the Indian application to my international application. So it is an extension of the same only.
All right, so now I will take questions from the people who are seeing it live. What is the approximate fee for patenting?
The fees are, if you're filing in your name, it is 1,600 for filing. If your institute is filing, then it is 8,000. So this is the filing fees. At various stages, the filing fees vary, and that depends on who is filing it. There are different categories, and you have to decide which category you fall in.
There's one question which says, through my research, I had introduced some new damage indicators for assessing RC members and published in Springer Journal. Meanwhile, I received email from some patent agency from India for getting research patent for the same. Are they authentic or fake?
On this platform, you're making me speak about my fellow or my rival patent attorneys, whether it is right or wrong. But ethically, whatever is published is not supposed to be filed, because eventually it shall be rejected.
I hope
And
the person
getting
was...
getting such notification is ethically wrong. And then it is up to you to decide whether you want to be in contact with them or not.
I hope the question is answered to the satisfaction. There's a question which is asking for difference between patent, design patent, and copyright.
Okay, if I simply answer to this question, that intellectual property is nothing else but the idea. And when idea is expressed in different formats, different intellectual properties take its shape. So when there is an idea which is literally expression or artistic expression, it goes under copyright. The standard or very known examples are paintings, poetry, book, TV serials, movies, plays, musical pieces, etc. When it is for the aesthetic use, for the purposes of eye only, my fellow speaker, Mr. Nakul, took entire session on the design yesterday. So when it is appealing to only eye aesthetic looks, it falls under design. But when there is any technical problem looked at and then technical solution is provided through scientific efforts, the same idea takes you towards patentability. So patent here plays the role.
The next one is, can the applicant and filing be the same person?
Yes, that's what I mentioned in my inventor and applicant. Inventor and applicant can be same or different.
A lot of thank you notes, ma'am.
It was all my pleasure.
Gopinder, we have
I'm struggling to the questions.
We can take 1 or 2 questions if there are any important questions.
Sure, sir.
How is the protection of our idea secured while filing the patent?
So the journey of idea should be taken further, make it a feasible product or process backed by technical support or an experimentation, write the patent application, prepare the forms, file along with the fees, follow the timelines, and get the patent grant. That's the journey from idea to the patent rights.
Next, after publishing the technical work, can we file for a patent if there is any advancement in the technology?
My answer is, if the advancement is significantly novel, significantly advanced, then only you can file or you should file a patent.
Okay. Next, after e-filing, we have to submit the hard copy to patent office, but as of now, it is not possible. Kindly suggest.
These days they have stopped taking any paper submission. So no paper filing, post e-filing is required, except in certain cases where they really demand in the form of affidavits.
Next, if anyone fails to submit response to the examination report in the allocated time, what will happen to the patent?
When any timeline is missed, including complying to first examination report, the patent is abandoned and it cannot be recalled. So one has to be really careful for the timelines. When they are not able to meet with those timelines, there are certain extension of time which can be filed at certain stages. If that option is available, you kindly file well in advance so as to enjoy that extension and to keep your patent application alive.
The next one is, can we file patent using online mode? I think the answer is yes.
Only online mode.
Only online mode.
Yes.
Okay. Next, do we require complete product or just prototype for filing patent?
See, prototype is also fine. Product is also fine. Understand the idea behind it. You are not going to provide either prototype or product before the patent office ever. Neither the examiner or controller is going to come to your premises and check whether you have prepared the prototype or product. But the requirement of complete specification is you are going to provide complete details backed by complete supporting data. Having said that, and not allowing any amendments in future, kindly have your final product ready. May you call it prototype, may you call it product.
Can you elaborate the publication step in the process of patent?
This is your intellectual property in the form of patent. Under the Property Act of India, any property, when it is claimed by any person, a natural person or a company, has to be published and invited for third party opposition. Similarly, patent is also published, and if there is any third party opposition, that has to be met with for the claim or the title of that particular property. So the purpose of publication is only to deal with those third party opposition, if any. So it's a procedural aspect of the patent prosecution.
Any funding is there for patent processes?
I think Sunil Bhai is the right person to talk about this than me. Because institute play a bigger role in getting those fundings than any individual attorneys. But yes, there are fundings available.
Can you tell the difference between PCT and international patent?
PCT and international patents are same. PCT is Patent Cooperation Treaty, which is also international patent. So both are same.
Can educational test be patent?
No, it falls under copyright because it's an expression in the form of text. There is no scientific efforts, there are no technical problem, no technical solution.
Duration of validity of patent obtained, is it lifetime?
20 years. It is 20 years. That's I mentioned in my slide. 20 years, no more, no less. "20 years from the date of filing."
Another question is, we feel as we are reaching towards results of our finding, should we go to file for patents?
Of course, yes, this is the best time because now you're confident that it is working properly. At the same time, you have the experimentation data ready. So this is the golden time.
Next, what is the total expense for patenting process and how fast can it be done?
So it's a long answer and we are in short of time. I request the participant to go through Indian Patent Office website. It would give you a very clear answer about this question.
There's another question on COVID-19. It reads, COVID-19 test kits are required to be used immediately. How to patent? There is no time for filing.
There is a time you can file it even overnight. And after filing, you can make it for public use. So the way in which the pandemic is spread, you have to be equally prompt, in filing and make it available.
Next, what precautions are required while filing patent in food sector as per presentation under section 3? Ingredients level optimizations are not considered for filing.
I agree with the note that ingredients or the recipes or mere admixture would be completely or rudely rejected by patent office under section 3. So kindly don't put much effort if it's a mere admixture or a food recipe. Patent shall not be granted.
Next, what type of mathematical work can be patented?
So mathematical work per se shall not be patented, but from that mathematical work, if you convert it into any product, that shall be definitely be patented. I have a wonderful experience of working with an dentist who came up with a mathematical calculation which talks about less impact on teeth by providing a new orthodontic wire. So my actual product is orthodontic wire, which was patented widely in India. Before PCT, it was very well acclaimed, and even in US, it was granted. But my experimentation data was nothing else but the mathematical calculations to prove that yes, I'm doing less damage to the jaws and tooth and gums.
All right. I think in the paucity of time, I'll take the last question. Is there any demo booklet by government for drafting a patent?
Yes, you will find very useful and impactful information on Indian Patent Office website, and they conduct various courses also periodically. So you can really take help of them, as well as other sources are also there. They are private in nature, so you can take help of them also.
Thank you, ma'am. I think the rest of the questions to all the people who've posed, we'll try to find a way to answer all of them. I'm sure Mr. Sunil Gangwani will help us collate them and we'll be able to answer them sooner to all of you. Thank you, and I'll pass this to Mr. Sunil Gangwani.
Thank you, Ropi ma'am. Thank you, Anjula ma'am. Now we are almost at the closure of this 2-day workshop. So before I close, I would like to request our Director General, Professor S.S. Manoharan sir, for few key words and input.
Thank you so much. It has been a brilliant time of engagement. And at the outset, I want to thank Mrs. Anjula Mehta, the CEO of IPPO, for coordinating and helping us with this seminar, and also bringing YJ Trivedi and company and the two leading attorneys, Mrs. Gopi Trivedi and Mr. Nakul Sherdalal. Both of them did a brilliant job in the last 2 days. And definitely this is a time for us to recap on whatever they have said. But we would also like to be available for more mentoring, because when we try to put our ideas, our research findings, it will take a lot of time, and therefore we have decided in part to keep this dialogue open, this interaction open, and to facilitate further interactions. We might come again a week from now or 2 weeks from now on a Zoom meeting on this format, but we will let you know. If you have more specific questions, some which are posted already, which is not covered, we would like to do only a Q&A session exclusively without any presentation. We might just do a Q&A on some of the vital questions that the participants have posted. So to this end, may I request the participants to send your queries to ippopl.com. You can go to the website of IPPO and you can send your request, or you
I'll
can
just repeat it. Sorry,
yes,
sir.
sir.
It's info,
Yes.
info at ippopl.com. Thank you.
Okay. Otherwise, you have been corresponding with the PDPU for registration. If you could do that, we will channelize the questions. We will organize with the attorneys to answer this question. So you may hear from us a week from now as to how we would like to help you, mentor in formulating your ideas and take it forward. Definitely, this will be a very engaging exercise. And I want to thank all the participants for having come here. maybe I'll leave the pleasure of thanking everyone to Mr. Sunil, because he did coordinate the entire procedure. But at the end of the 2-day session, I have one small request. I have showed in my initial comments that we are far behind some of the nations in terms of number of filings. And no common man can go to IPO office other than the academicians and the industry people. And if you look at the ratio between the number of patent filing that happens between the academicians and industry, it is not even 1/3. We are very meager in our filing exercise. So I think during this lockdown period, you have to really warm up and come out of your inhibition and come out of your hesitation and start putting things in word, because we are very good in publication, because we know how to publish. We are always in the mode of publication, but the language got to be very different when you talk about patents. So that's where the attorney's help comes handy. And this is not like the way we write our publications. So I'm requesting all of you to spend at least 1 hour in a week to document your result for either a design. Design documentation is fairly simple compared to the provisional patent or the complete specification that you're writing. So you may try and take one of your help, and especially the attorneys who came on board, or you can direct it to IPO. So with these few words, I want to thank all the institutions for joining with us. And if possible, we will try to organize a follow-up meeting, more as a mentoring meeting in a week from now. Thank you so much.
So much.
Thank you very much, sir. Thank you, Vajay Trivedi. Thank you, Vajay Trivedi and company, for all your expert sharings, and Nakul Bhai for yesterday's session, Gopi ma'am for today's session. I wholeheartedly thank IPPO and CEO Anjula ma'am for all your contribution time and compiling all the hundreds of questions and then asking important questions for the session. I thank PDPU DG sir, Professor Manoharan, for motivating me and the entire team to bring out this online workshop on intellectual property rights. I wholeheartedly thank you for AICTE for their support, and all the institutions, faculty, professor who have joined live in the Zoom session, and also there are viewers on the Facebook Live. So I thank to each everyone, and we'll back soon with some more content and some better mentoring session and other programs. Thank you very much. Thank you very much all. With this, I would like to request all to leave the session, and we are ending this meeting here. Thank you very much.
Thank you. Thank you.
Thank you, sir. Thank you, Sunil
Thank
bhai.
you. Thank you, ma'am. Thank you.